Welcome to the Cheeley Law Review. My name is Ben Burnett. My guest today is the founder of the Cheeley Law Group, Bob Cheeley. Bob, welcome in.
May the court come to order.
Oh. Bob, one of the things I want to unpack with you are timelines and cases. I think that is something that separates your ability in research from the average plaintiff's lawyer. Talk about how you use timelines in some of the cases that you've used them in and how powerful they are to a jury.
I love timelines. They're one of the most powerful things to tell the story. Every case is a story, and you've got to present that story in a very compelling way so that the jury, number one, they pay attention and that they'll remember what you told them. And so timelines are great because you can use them often in opening statement to summarize for the jury what you're going to prove in the case. And then during the trial, you can call various witnesses, particularly those who have knowledge of the documents that are referenced on the timeline, to talk about what did the defendant do or what did the defendant know and when did they know it. And then thirdly, you can use that timeline at the end of the trial and close an argument to remind the jury what you just proved to them in the days or weeks of that trial. And so it's great because, I've had some timelines back in the old days before we had PowerPoints presentations, which I typically use now, PowerPoints. But in the old days, you had to have a physical blow-up mounted on foam core board and printed. You would have a particular date, say March 4th, 1972, and you would have a letter or a reference between certain individuals at a big company, say General Motors, what the topic was, and a meeting might be dealing with fuel tank design. One of the great things is that you get a timeline in front of a jury, and it's there for the whole trial, and you can keep going back to it and pointing at them with various witnesses. And the jury is reminded over and over again.
They knew this when.
They knew this when. And I had another great example from, May of 2022, more recent, from down in Fort Lauderdale, Florida. Tried a case against a fella who committed fraud against my client in a partnership agreement in a business. And we were able to utilize emails. I love emails because you can take those emails and rather than just holding a piece of paper up in front of a jury with the email, you can put it into a PowerPoint presentation, put it up on a screen, and show the whole document, and then zoom in on whatever number of words or sentences that you want to focus on. And so in that case, had this timeline that I worked on for probably 3 or 4 days leading up to trial, and to perfect it, I really believe that after opening statement that the jury knew everything they needed to know, absolutely be convinced the defendant was liable and had breached fiduciary duties to my client, his partner.
When you look at timelines, is it a strategic advantage to point to that document over and over and over so the jury just knows it as well as you do?
Without a doubt, that's true. It's so important to be able to tell jurors using both words and visuals that reflect words. The retention rate is up around 85 or 90% when those two things, visual and audible explanations, are given to evidence. So it's so important to have both, and really just sinks in. And in that case, we got a verdict of $40 million, and the jury was only out right around three hours.
Probably talking about your timeline.
Yeah, and verifying the way in which we calculated damages.
When you look, are there other ways? Do you start formulating that process in your head long before an opening statement?
Yeah, I start putting together like a folder with key documents in it throughout the course of a case preparation. So I know by the time we're 2 or 3 weeks out from trial date, the documents that I think are most important to show on a timeline. Sometimes I don't actually finalize the timeline until the day before the opening statement, and we just keep going back and keep going over it and questioning, okay, is there a better way, or do we really need that document? Because we want every punch, if you will, to be a knockout punch. Every document needs to be something that delivers a bloody nose to the opponent.
Do you ever run into objections to timelines?
Oh, yeah, practically every time. The defense lawyer will object, trying to keep it out because they don't like the impact that they know it's going to have upon the jury. As long as it's factually true, which I don't add one single dot or cross a T that's not from an actual document. So it's verbatim. So as long as it's factually true, judges always let them in. But it is nice to be able to counterpunch. It's nice to put up these PowerPoint presentations, one document at a time, and they build on each other. And I may be summarizing 2 or 3 years worth of evidence in an opening statement, for example, using a timeline. And it's kind of neat. Defense lawyer to stand up and object and
get hit again.
I said, well, Your Honor, this is right out of the document. I don't know why he's objecting.
This is their email.
Yeah. So, then they sit down and the jury thinks, well, what's he trying to hide?
When you look at like the last 4 or 5 years and everything has moved to email documents, everything's moved to online footprints, how does that change the way, and what are the advantages that you guys offer when it comes to technology today?
That's a great question. Back in the 90s, before, the internet became widely used in the mid-90s, when we would request documents from a defendant in certain categories, let's say, for example, in a case against GM involving their pickup trucks with side saddle fuel tanks that catch fire, we would have to go to Detroit to what they called the reading room at GM and sit and sort through hundreds of thousands of pages of documents to find the documents that were responsive to our requests. Now everything in digital format, they can just send it to us in a zip drive or in the cloud, and then we can sort it and look for keywords. That's made the job a lot easier.
I would guess in some ways, though, it's not foolproof. I imagine if you have something to hide, people still try.
Yeah, that's true. And
which only makes you look even more guilty.
Sometimes you really do have to assign enough staff to go through every document, because you may find that needle in a haystack that really makes the case.
Bob, I imagine that cases are won and lost in what you can argue and what you can prove. How important is it to continue to harp on the timeline?
It is my belief that any successful trial lawyer will not enjoy much success if they don't know how to synthesize large volumes of evidence down to the most vital pieces of evidence from documents and present it in a cogent manner that a jury can see and hear as you explain it to them. Looking back over 41 years of practicing plaintiffs representing people who have been wronged, we have the burden of proof. The plaintiff does. We have to prove by preponderance of the evidence, and that's like tilting the scales of justice slightly in my client's favor. I don't ever want to just tilt it slightly in our favor. I want to tip it all the way in our favor. And the way you do that is with timelines and documents. You know that you're getting to your opponent when your opponent is standing up and objecting in front of the jury on the grounds that the evidence that you're showing the jury is what they say is prejudicial. Well, all evidence is prejudicial. It's so clear to jurors that they're just trying to hide information from them, and I love it when that happens.
This has been another episode of the Cheeley Law Review. Have a great week, everybody.